Let's face it, it's natural to have an interest in recruiting staff from similar or competing businesses. They're likely to already have a good grasp of the industry and market and be well placed to hit the ground running from day one. But given how common post-termination restrictions have become within employment contracts, you understandably want to ensure that your recruitment efforts don't land you in hot water. There's no two ways about it. Post-termination restrictions are difficult to enforce. As we live in a free and competitive market, such restrictions are generally regarded as a restraint of trade and are therefore automatically void under English law. Although a court will uphold them if the employer can demonstrate that they're required to achieve a legitimate proprietary interest and the restrictions go no further than is necessary and reasonable to protect that interest. But what does that mean in practice? Well, it essentially means that the drafting and scope of the restrictions is always absolutely critical as to whether they have a chance of being enforced. And just as crucially, the restrictions must actually be reasonable and appropriate for both the individual involved and their role for them to be enforceable. Now, while the restrictions bind the individual themselves, those recruiting must be aware, as they can also be exposed to claims that they've induced the employee to breach their restrictions. For this reason, it's important to always ensure that you have visibility of someone's restrictions before they're employed, particularly if they're coming from a competitor. With this oversight, risks can be assessed and an appropriate strategy for the recruitment can be put in place. We've seen a surge of instructions in this area recently from clients on both sides of the fence, and it would appear there's currently considerable appetite to test the waters of what might or might not be enforceable. In our experience, few cases ever get much further than pre-action correspondence, but there's often much that can be gained through such a process. It's therefore always important to be prepared for potential action before offers are made. Being on the back foot is never a good place to be.